definitely want to have your fundamentals down. That's the most important. So yeah, I just wanted to basically give everybody what the fundamentals of debt collection really are. And again, the fundamentals are important for everything. I've been in court myself, um, representing myself and actually standing in as counsel for people. And I'm not a licensed attorney, a barred attorney. I hope I never am one. I don't think I'll ever sign up for that, but I've had my experiences, and I definitely have seen the fundamental principles of law have a serious effect. Now we're at the point where we see that, no matter how right you are sometimes in these fundamentals, they still like to kind of run over top of us because they're not used to anything but their process and procedure. No matter what the hierarchies of law are, they still have to function by their process and procedure because they just don't know anything else. So it should be more of our responsibility to try to communicate properly, in a way that we come prepared, we come with respect, we come with professionalism. We're not there to hang anyone. We're merely there to protect ourselves and know what our rights are and how to implement them. So with that being said, we're going to go ahead and get started here on debt collection. Now, debt collection, for the most part, there's two facets to it. You have unsecured debt and secured debt. We're specifically going to deal with unsecured debt. Secured debt, you really can't get to invalidate the account, which is what we're going to go over. We'll get into that more in a little bit here. Really, what protecting yourself is all about here is using an invalidation of account process. Now, I began working for a company about 7 or 8 months ago that actually took this process and made it into an industry. In the debt collection world, the debt collectors do not like us. The banks do not like us because we're using the law and we're holding them to it. It's a great thing, but there are some backlashes to it, and we'll go over those too, and we'll talk about how to handle that. So being in this for 7 or 8 months, I've seen quite a bit of different angles, how these debt collectors come at people, their little tricks and the things they do. So there's quite a bit to know just from the experience side of it, much less the study side. I understand there's people on tonight from different countries. We're primarily going to talk about some of the laws that we use here in the United States, but that doesn't mean they don't exist in your country. They do. They exist in every country that is a commercial entity, and just about every country is a commercial entity. So rest assured, even though I reference the U.S. laws, they're there, and you can really just do a Google search in your country and find out, debt collection laws in the country of, or however you want to word it in Google, it'll come up and you will find them. And they're almost all uniform, which is interesting throughout all the different countries. So as that said, we will go ahead and we'll get started here on the basics. The first thing about the account, when you have an unsecured debt, let's say a credit card, or something that you didn't put up property for, okay, the account for a debt collector to take over, it has to go into default. Okay, and you'll see we have the word alleged account there because everything is alleged at this point. Nothing is a fact. Okay, so what happens is you get a credit card, you run it up, let's say $5,000. You can't afford to pay it. Let's say Capital One Bank comes after you, and they're blowing you up with phone calls, and they're sending you letters, please pay this, and you can't do it because you just don't have the money. After a certain amount of time, they have insurance on these accounts, and after a certain amount of time, that account will get charged off. Okay, so it has to go to default first, which means you're not paying on it. Then it goes into default, and once it's in default, it gets charged off. And basically what happens is the bank gets the insurance for that debt. So if it's $5,000, they get 15. So they've already made 10 off it, right off the top from the insurance. Now, a lot of people think that, oh, well, that's not fair to use their insurance. Well, if you understand how insurance and everything works, there's no fair about it. That's what they have this for. So when they take and charge off these accounts, okay, they're closed. So Capital One closes that account, but they only leave it open for collection purposes, which is an interesting concept in itself. If the account is closed, how's it open, right? Well, they leave it open for collection purposes. So what they do from there is they then give it to a debt collector, or I should say they don't really give it to, but it's sold. So they basically, the debt collector comes in and buys this alleged debt. Well, what happens is they don't actually buy the debt at all. They actually buy the information. So they buy your social security number, the account number, all the statements, all of that stuff is what they have bought for. Let's say you have $5,000, they probably pay $200 for that $5,000 account. Okay, so now this third party, this debt collector that you don't know, you don't have any contract with, you don't know them from Adam, they pretty much come in and say, okay, well, we're going to charge you some fees on top of this because we're collecting on behalf of Capital One, and we're collecting $5,200, and I'm sure their fees make up for the little bit that they paid for the alleged account. So, now you're getting hounded by this debt collector who you think works for Capital One, is collecting for them. Meanwhile, they're not. Capital One's been paid. They're happy. It's charged off. They're on their way. They could care less for the most part. Although some things have changed in the law recently here in the U.S. where it kind of makes it look like they really care, but everything's an illusion when you get into this stuff very deeply. But anyhow, so then they charge this account off. They give it to the collection agent buys it rather. Then they come after you. They're blowing your phone up. They're calling you nonstop, and they want to collect on this unsecured debt. Essentially, what they're doing is collecting money for free. Okay, it's kind of like someone at the gas station coming up to you and saying, "Hey, you owe me money," and you go, "Well, who are you?" "It doesn't matter. You owe me money." Pretty much the same thing. There's not much difference in it. They want the $5,000. They're making $5,000 plus their fees, and you have no idea who these people are. You have no contract with them. So basically, they're coming at you from a standpoint of, we own this account, but yet they've never proven that they own any account. They haven't proven they have any account. They just sent you a letter that says you owe them money on behalf of, or they're contacting you on behalf of. But there's no contract, there's no evidence, there's no nothing. So there's laws in place for the consumer to protect you from these debt collectors that do this. And I always say, if there's a law that says you have a right to invalidate an account, then that must mean there are accounts that are invalid. Because if they weren't, why would you have to have a law for it? It's a very simple equation, So what we have, again, is a collection agency that you owe nothing to, and you have a right to dispute that very point. So you have rights, okay? The law protects the consumer. Believe it or not, there are laws in place to protect the consumer, and there's many of them. Here in the U.S., we have the U.S. Code, and that a lot of these businesses, of course, have to follow that. And all laws, when they're codified, okay, or codified, are just what they say. They're a code. So you got to jump around. You got to look at the different laws of debt collection and kind of weed through and figure out the code. There's a lot of people on the internet who are very brilliant and intelligent and have looked through this stuff and researched it and have great information. It's almost like you really don't have to crack any code anymore.
I'm Paul from Vancouver,
you just have to
co-owner
find
of
where
Blue
the
Studios.
information is at this point, which is great because it saves us a ton of time. Years ago, when I did this on my own, it took me forever. It really did, because I had to do a lot of research and figure out the process, and I did a ton of research to figure it out. And now I do it so much, it's very simple. The company I work for handles probably about 1,500 accounts a year. And I'd say out of those 1,500, we have about a 10% um, rate that's unsuccessful rate. Let's put it to that. So we have a 90% success rate, and we'll get into that and what that means later also. So in the U.S., we have the Fair Debt Collection Practices Act. That's a big one. You can definitely find your consumer rights there against these debt collectors. Truth in lending. Everything has to be upfront. There has to be disclosure. That's huge. There's very many laws in that. And again, I apologize for those outside the country, but if you do your research, you'll find that there are laws that are very similar in your country. And that's not to say that I may not venture out and start doing that and compiling some of this information for people to pull it together. So, because I'm curious too, and I love to study the law. So my curiosity gets me in places where, I wind up doing things, and then I compile this information for people. So I just might do that. So stay tuned, and, I hope I can pull some of that stuff together for y'all. But please, you always must do your own research and at least check research that others have done. If you're not sure about something and you're looking at someone's research, always check it, because you never know. They may have made a mistake. Heck, they may not have even researched it. They may be using someone else's research. So it's always good to do it yourself anyhow. We have the Fair Credit Reporting Act, which is a huge factor in this too, that many people don't realize. When you go to fight off these collection agents, what are they going to do? They're going to mark up your credit report, and then you go to buy a car, you try to buy a house, you can't, because your credit's shot. So there are laws out there that allow you to dispute those remarks on your credit report. The first important part is what we're discussing here tonight, is to invalidate that account first. That's huge, because once you invalidate those accounts, they can't mark them up anymore. Then you can go back to the credit bureaus and dispute your credit report remarks and take those, where you can have all of those negative remarks removed. Judgments are a little harder. If you get a judgment, it doesn't necessarily get removed, but there are remarks that you can put next to it that basically make it null and void when a particular institution is looking at it to lend you something. They'll look at these remarks. For instance, the debt would be satisfied, or the judgment would be satisfied, and that's good enough for them. They just want to see that it was satisfied. So judgments sometimes come off. More often than not, they don't. But again, still, you can have it repaired, and you can have your credit report repaired even with a judgment, to where you're good to go. Someone looks at your credit report, you can still get bonds if you have a company that relies on bonding and things like that. So again, that's more of the detail we can get into at a later time. The Credit Card Act of 2009, that's also a good one, and the Fair Credit Billing Act. So here we have 5 acts right here that are pretty powerful, and there's actually more. So again, it really pays to do your own research. Do a Google search, get on there and just start doing your own research. You'll be amazed at what you'll find. A lot of people find that reading the laws, like reading stereo instructions, I'm not going to lie, it's not the most exciting read. But for me, I'm one of those weird guys that really enjoys it, because I start seeing how the puzzle pieces fit together, and it empowers you. That's the biggest part about doing your own research and understanding how these things work, is you're giving yourself power. And if there's anything that the opposite party, doesn't like, is the fact that you're intelligent, you've done your research, you're organized, and you're empowered. And that kind of really takes the wind out of their sails. So what we do, the company I work for, is called debt invalidation. Now, when this third party that you have no contract with, that you don't know from anyone, comes to you and says, you owe me money, by law, they have to give you a certain amount of time to dispute that. Here in the States, it's 30 days. So once this account gets charged off and it gets sent to the debt collector will then begin a communication by phone. They'll usually blow your phone up, and they will also send you a letter, which they must do. They must give you 30 days to dispute the validity of the debt. Okay, and as I said earlier, if the debt was purely valid all the time, why would there be a law to give you the right to dispute it? So that's essentially the crux of what we do at the company I work for is debt invalidation. Okay, now what we do there is we act as someone's representative to invalidate the debt. You can do this on your own. And that's what we're here to bring to you is to show you that these things are available, and going forward put together some stuff to show people how this actually works and what you can do to do it on your own, and what the end results are, and so on and so forth. So you have 30 days to dispute the validity of the debt. Okay, that means quite a bit, because there's some key points when you dispute the validity of the debt that you want to put in your invalidation paperwork that really drives it home and makes them jump, basically, and start trying to. They come up with all kinds of ways to try to get around you. But once you do that, once you send them this invalidation paperwork, they must cease collection activity because it's now in dispute. So they cannot collect from you. You have the right to dispute. And remember, you're not saying, hey, I'm not going to pay this. You're never saying, I'm not going to pay this. I'm just disputing that it's even valid. Let's start there. And if it comes out that it is, no problem. I will pay you. But right now, we're disputing this. Collection activity must cease. So in your paperwork, it will lay all that out. And by law, they should know this, although a lot of them just run right over top because they know you don't know it. The phone calls must cease. These guys are relentless. They will call your family, your work, your neighbors. They'll call anybody they can to try to get at you. In your invalidation paperwork, you want to put a cease and desist letter, and it's merely telling them that you must cease and desist all phone call communication. All communication is to be in writing only and by mail, and they have to do it. That's in the States here. That's part of the Fair Debt Collection Practices Act, and I'm sure, like I said, in other countries it's there as well. I just did a search and found in Canada where these laws are located and stuff, and we'll go over that in a little while too. So cease and desist phone calls is huge. That will basically take a lot of pressure off you and keep your blood pressure down. So the collection agency must provide proof of account. Okay, so what you're essentially doing by invalidating the debt is you're saying, hey, collection agency, you must provide proof, not evidence. We want proof. Okay, evidence is completely different from proof, and for those who haven't really looked too much into the law, get yourself a law dictionary, because words are not what they seem. They have completely different meanings. We have 3 Englishes here in the States. That's standard English, law, English, and slang, and that's the truth. So it's best that you study all 3 depending on what situation you're in life. So they must provide proof of the account. They cannot provide proof of the account because they never had the account. The third-party debt collector is just a debt collector. And, on a side note, I know a lot of people have issues with taxes and stuff. To be honest with you, like here in the States, the IRS, they're just a debt collector too. They're not an actual government agency, and that gets into a whole other ball of wax there that we don't really want to touch right now. But the collection agent is just a third party. They don't have the account. They never had the account. They only bought the information on the account, which is nothing. And it's a shame. So they spent their money. Oh well, that's not your problem. So you get into the debt collector behavior at that point. What starts to happen is they send you the collection notices. They start basically blowing up your phone with threats and intimidation in their notices. Their phone calls are to everyone they can find, but believe it or not, there's a limit on their phone calls too, and you'll want to look in your laws and find what are the limits as far as time frames. Is it between 8 in the morning and 9 at night? I believe it's here in the States. Some of these guys are calling at 6 o'clock in the morning. So once you know these things, you can now start to document their behavior. What are they doing? What's the debt collector doing? And do they even know the laws? Because a lot of times they don't. And a lot of times they're not even properly licensed. So that's another area you want to look in. And once you start learning these laws, you can begin to really watch their behavior. You can begin to track their behavior, and it may put money in your pocket at some point. I know there was a case in Florida where basically these people were just awarded $1 million because of unfair practices by debt collectors. And they racked up a ton of money, well, $1 million in phone calls. So when they're calling you, and let's say you sent them your cease and desist, and they continue to call you, they rack up, at least here, they rack up $1,000 per phone call. I've got one client that's up to like $15,000 right now, and he's like, hell, let them keep calling. He's having a blast. He's like, I don't care, they can keep on it. He's just racking it up, keeping a call log because they've been notified. So what will happen is essentially you will rack all that up, you'll keep a call log, and then you'll go to a debt collection attorney who I believe will work for basically a cut of the fines that you'll get. So he'll take his percentage out of that. So there's no upfront money. So you'll take it to him. He looks at it. It's pretty easy to see when it's an open and shut thing. Yes, I sent them a cease and desist on this date. I've got the evidence, the proof, the whole bit. And here's my call log. I took a picture of my caller ID. You want to do those types of things and have everything logged out. Evidence. Build your evidence. That's huge. And then once you get into court, you can get awarded thousands of dollars for these guys not knowing the law. So it's amazing when you see how poor they are at actually knowing and following the law. Their other thing that they love to do is to make you feel immoral. You have an obligation to pay this debt. They yell at you on the phone. They say all kinds of things, Oh, you borrowed this money. Well, technically you didn't borrow anything, and it was unsecured to begin with. So if it was unsecured, they should have known they were taking this risk. If there was anything even lent to you to begin with, which you start going down the rabbit hole a little bit, they really didn't lend you anything. Not to mention, this guy on the other end of the phone or woman on the other end of the phone can't even explain to you that they actually own the account, nor will they ever sign on it that they do. They will never fill out an affidavit that they do. So they're just trying to make you feel bad. You borrowed money. Well, folks, you didn't borrow anything. And the bottom line is you don't owe anything if you didn't borrow it, and the person claiming that you borrowed it can't prove that they lent you anything. You don't owe anything. So don't feel immoral about it. The bank's been paid. Yeah, they've been paid by insurance, but they've been paid 3 times the amount. Now they're coming in. Now some stranger's coming after you. Well, what's a stranger coming after you for? You don't know this guy. I work day and night to pay this guy. No. Sorry, that's not going to happen. So I don't feel immoral about it because I know that it's not a moral issue. It is about facts, and it is about what was lent to me. And as long as you can prove that you lent me something, by all means. Because if my neighbor comes to me and lends me $2,000, he's going to be the first one to get it back because I know he put cash in my hand. When you got unsecured debt, nobody gave you money to put in the bank. You didn't get a check. You got numbers on a screen. You got a ledger, which has never even been shown to you. So you don't even know what the ledger's doing, or what's on the ledger. So anyway, keep that in mind. They will try to make you feel like you're immoral, and you're not. You're just upholding your rights and doing what you need to do to make sure everybody's following the law and that everybody's playing nice. They'll scare you into paying. They will threaten you with lawsuits. They will threaten you with things that they don't even have the power to do. I've had some of these guys just yell at me, just completely yell at me, and I just laugh because I'm like, you're getting real worked up over here about nothing, and you're trying to make me scared. So I don't know what the problem is here, but you need to relax because I don't have any money. That's always my thing that I would tell them. I don't have any money, and then after a while, I just don't even pick up the phone. It's not worth it. But once you get them to cease and desist, that should all stop anyway. And if it doesn't, you're just racking up money in your pocket. So, don't fret about that. So, the relentless phone calls, we talked about that quite a bit already. You're going to get those to stop by sending the cease and desist. So the possible end results, there's quite a few. Once you do this, first off, you're going to really upset the opposing party, okay? Because number one, they don't like to follow the law. And when you show them that you know what the law is, it gets their panties in a bunch, and they really don't like to play nice. So what happens is they can, if they're an attorney. Now let's draw some lines here. A debt collector can also be an attorney or a law firm. Okay, they will come at you as a law firm, but they are still just a debt collector. They are not in any way, shape, or form more empowered than the debt collector, unless they have a contingency contract with the original creditor that says, if you cannot collect on this debt, I'm not sure how it's worded, but I'm sure in so many terms, if you cannot collect on this debt, we are responsible. We will then sue the debtor. Okay, the original creditor has the right to sue you. So this law firm acting as a collection agency will now turn their hat around and go, oh, but wait a minute, we've been hired by the original creditor. We're representing them. We are now going to sue you, on their behalf. So basically Capital One or whoever your original creditor is becomes the plaintiff. Okay, now the debt collection attorney turns his hat around and he's the attorney for them. So you got to be careful. That can happen, and there are ways to handle that as well, which we're probably not going to get into tonight. But just keep in mind that that's one of the end results, is that they can turn around and pass it back to the original creditor. Now, there's also a lawsuit by the debt collector that could happen. Okay. Now, these are all possibilities, so keep in mind that anything can happen. So you go through this. Now the debt collector decides he's going to sue. Well, this is great. This is perfect, because if you've done your diligence and you have done everything properly according to these fair debt collection practices type laws and things like that, they're really up the creek without a paddle, because now they have to pay an attorney, because they're not attorneys. So they have to pay an attorney. They're putting more money out of their pocket thinking they have a slam dunk, but you've got all the evidence notarized and proof in your paperwork that they were notified within the 30-day period and that they did not provide any substantial proof of account. So usually this can be won, okay, but most attorneys do not like to go in and fight against, well, the brotherhood, essentially. So again, I can't give any legal advice or anything like that or tell you what to do. But if you feel confident enough, you can go in and use this paperwork and basically go in and say, hey, wait a minute, here's what the law says, okay, and here's what I've done, which pretty much follows the law all the way through. And now this debt collector is trying to sue me and get a judgment for this. No, it doesn't happen. Whereas an attorney might say, oh, well, we put our answer in, we filed our answer, and we're going to have to go to settlement. Usually the attorney always wants to go to settlement. And to me, going to settlement is not quite doing what you set out to do. You set out to invalidate this in the fact that you do have the right not to pay it because it's invalid. So the lawsuit by the debt collector, to me, can be a very good thing, depending on how confident you are, how much you know, how much you've studied. If all your ducks are in a row, you should be able to go in and slam the door shut for the most part. Now, if you do go, oops, I'm sorry, went a little bit ahead there. You can, once in a while, get a success letter. And the success letter is great, because that just says that you won. And a lot of times you don't get anything when the account is invalidated, which is okay. That's when you get the silent treatment. They don't say anything at all. But that's okay, because you've got all the proof and evidence that the account has been invalidated. So taking a step backwards to the success letter, that's great. They send that to you. This account has been closed. We're sending it back to the original creditor, yada, yada, yada. That's what you want. There's all your proof and evidence. You don't need anything further. Now, if they're silent, that's good too. They didn't say anything. They didn't come back with any evidence. They didn't do anything at all, so you're good. Okay, statute of limitations runs out on debt collection. They can't collect on you. They can't collect on that debt from you anyway after so many years. So you hang on to your paperwork. If another debt collector comes at you, you say, oh, hold on. No, sorry, you can't collect on this account. Here's all the proof and evidence I sent to ABC Collection Agency that they failed to verify the account without a response. You may contact them and see if they have and chances are they're not going to contact them because they bought it from them. Okay, so now the next collection agent that's trying to collect from you looks at your paperwork and goes, oh, we just bought some debt that we can't even collect on because it's already been invalidated. So you basically let them know, hey, you can't collect on this. It's already shut down. It's been sold and sold again and sold again, and it just can't be sold anymore because it's over. I basically have the proof and you don't, and that usually shuts it right down. And again, you'll get this silent treatment. They won't respond. They're great at blowing you up when they want the money, but the minute you invalidate the account, they don't want to talk to you. They don't want to say anything. They don't want to write to you or nothing. Speaking on that, in terms of communicating, you never, ever, ever want to do anything over the phone anyway. Everything must be in writing. The phone is just such a bad deal because they're recording on their end. They want to lock you into a payment. Oh, well, you said you would pay, and it's recorded and right now. You don't even want to deal with that. Everything must be in writing. So let them go silent. Not a problem. You don't need a success letter from them. All you need is your paperwork that's been notarized through the allotted time within the law, following the letter of the collection law. Once you have that, you're good. You don't need anything else. And again, we do like 1,500 or so accounts a year, and half the time we get silence. We don't get success letters. We've got quite a few success letters, but not on every account. The majority go silent, and they just don't bother anymore, which is fine. That's good too. So if they try to come back to us within the statute of limitations, that's when we pull down and say, well, no, in the year so-and-so, 3 years ago, this was invalidated, so there's no way that it's valid now if it wasn't valid then. Once it's invalid, that's it. It's always invalid. And again, what they may try to do is sell it to another collection agency. Not a problem. We just discussed that. You'll go in and you'll basically let them know you can't sell this anymore. There's nothing you can do with it. It's been invalidated. Here's all the evidence. So what you'll do with that is you'll take all your evidence, you'll make copies of it, and you'll send that to the next collection agency and pretty much shut them down. So it sounds like a pretty simple process, and it really is. It's just knowing what your standing is in the situation, knowing what your rights are and what they've put in there for you to dispute this debt. Now, if it does for some reason go to the original creditor and the original creditor decides to sue, or even the debt collector. Let's say the debt collector decides to sue you, and you go in and you're doing your thing, but the courts are corrupt and they're just shutting you down anyway. Best thing to do is just go for the settlement. Say, look, I don't have any money. I can't pay this debt. What can we work it out? And they'll usually go for 50% or sometimes even less. And a lot of times that's not what you want to hear for all your hard work and effort. But at the same time, sometimes it's better to just go with the flow because you could be fighting this for so long and it could be worse in the end. You may wind up, that's a personal choice. I mean, you may wind up hurting yourself more to continue fighting. The original creditor, if they sue, a lot of times you can call the attorney and say, look, I can't afford this debt. I can't afford anything. Yeah, that's why, I'm disputing this because I want to know if it's valid, but I'm at the point now, I just can't afford to pay this. What will you, what will you take? And they'll say, make me an offer, and you make them an offer, and you want to start way, way low, of course. So now you become your own debt settlement agent, and you're basically just trying to work out a deal with them. And a lot of times they will take it and they'll drop the lawsuit. Because remember, the original creditor's already been paid. They really, really don't care. They really don't care about the debt. Now, they make it look like they care, and the lower level worker bees think that it matters. But at the very high ends of these banks and the high ranks in these banks, they know it doesn't matter. It's all just a shell game. So anyhow, that's basically debt collection in a nutshell. We can, oops, one second. We can definitely take some questions because I'm sure people have questions, and a lot of times it takes a lot of time. So I don't mind spending a good bit of time on that. I wanted to give a basic overview of the debt collection companies and what they do and how they function and what the end result could be. Again, there's a lot of detail, and we can get into that in further webinars. It's not something that we can just uh, go right over tonight and you'll go, okay, I'm going to use this, I'm off and running. I don't suggest anybody does that at all with any particular process that is you're doing in court or is legal or lawful. You don't want to just take something and throw it out there. You've got to know what you're dealing with, and you've got to know the power of these people and what they're doing. I don't know that I'll get into an example of the paperwork. Well, we're definitely not going to do that tonight. I'm not sure when that'll come, but we'll do that. We'll go over what we'll do is we'll go over the aspects of the paperwork, what should be in there, what is going to make them jump and try to validate these accounts. And a lot of times too, now bear in mind, they will try to verify these accounts. They will send you, okay, your original contract and your statements, okay, but that's not a verification of account. That is a statement of account, and that's a verification of a statement of account. Statement of account is not an account, nor is it proof of account. So there are different tricks that they'll try to play to see how much you actually know and see what they can get around from you. So anyway, if we can, I would definitely like to open up for questions. I see that there are some questions here on the board, so what I'm going to go ahead and do is I'm going to answer some of these first if I can. Let's see. I have, is there a difference if the debt is to a doing business as company or a man? That depends. Yeah, I mean, if you owe a man, who lends you money out of his pocket, well, that's a different story. But if it's a legal entity, it's all applicable because it just has to be a legal entity. If it's your neighbor, obviously, yeah, you want to pay your neighbor back. These things aren't going to work. This is strictly for commercial entities that are under the Fair Debt Collection Practices and different acts in your country for debt that is unsecured. Remember, this is only unsecured debt. Doesn't have to do with mortgages or anything like that. You can't apply this stuff to mortgages or anything, or car loans. Actually, you can do car loans if the car has been repossessed and now it's being held. Now a collection agent's coming after you for that car. You can do it that way. But if you have the car in your possession, no, this stuff won't work for that. Are we going to get an example of the paperwork? You're not going to get, I can't give you an example of the paperwork my company uses because they have that kind of patented the way it's laid out and stuff. But yes, we will go and get into looking at some paperwork, how it's set up, the aspects of the paperwork, how to set it up yourself and things like that. I can't get into that tonight. Like I said, it would be way too much and we wouldn't get through it for you to use it anyway. So it's good to start with the basics of this stuff and then really build on it so that you understand it and you can actually use it. And I have another question that says, if the original creditor has been paid through insurance, is that information you can request through disclosure? That's a good question. I don't think so because that's their business. That's their private business for their accounts. I don't think you can request that. I haven't seen anywhere. I'm not going to say that you can't. I'm just going to tell you that I haven't seen it, and I know we don't do that. We definitely don't ask them for, disclosure on that particular aspect. So it'd be good for you to research, though, and find that out. I'm going to venture to say no because we would probably be using that angle if it was something that was valid.
One point I'd like to make is that you can ask for anything. They just don't have to disclose it. So I would ask for anything and everything and let them say no.
Absolutely. Absolutely. What is the difference between debt verification and validation? Well, first off, verification is just verifying the account. It's verifying that, oh yes, this person signed up for an unsecured credit card. Validation is it valid? Is the debt actually valid? Does it exist? did I borrow something? You know, verification is, oh yeah, it's verified that I borrowed something, but it's not, it doesn't mean it's valid. So again, I think if you look in your law dictionary, you'll find those terms more defined and you'll be able to see what they mean. Um, I particularly like Black's Law 6, but again, I think any law dictionary is going to show you the differences there. The name of the company that I work for is called Credit Shield, and there's another company called Debt Defense Services that we started and parted ways with them about 2 years ago. We do this on behalf of people, but it's a 35% charge. It's a 35% of the debt. And that's great. I mean, if you know, again, if you go to debt settlement to have debt settlement handle your issues, they're going to probably charge you 70, 50, or 70%. And then they're going to charge you their fee, which if you add it all up in the end, you're almost paying what you'd pay for the debt anyway. So we charge a flat rate 35% to do the forensic auditing, is essentially what this is. You know, invalidation is basically like a forensic audit. And then we handle all the clients' paperwork and stuff like that. So, some of the questions are coming in so fast.
I think the point is, again, that anybody could do this process on their own if they understand the process and follow through with the steps and gather their evidence, right?
Absolutely, yeah. And that's, I mean, I would rather see people do that. I mean, yes, I should be bringing business into my company, but to me, you know, this is consumer advocacy for the most part, and I wouldn't be much of an advocate if I was saying, don't worry about it, just come to us. You know, I think people should be aware so that they can educate others. So yeah, you can do all this yourself. You don't need to pay the 35%. Oh, the slide with the Consumer Protection Acts. Yeah, I can show that real quick. Again, these are U.S. laws. These aren't any other country, but again, there are relative ones in your country. Okay, I have one here. I'm disputing a smart legacy meter. The hydro says they own, and I am paying the services, but I'm disputing that other part of it, and they keep adding the alleged debt to the whole account. How do I ask them to stop making the account look like I'm still owing for fear of them disconnecting the electricity, which they keep threatening to do, knowing it's under dispute? Okay, that's a different issue completely, because that's not an unsecured debt. So this is only unsecured debt, and I don't really have a lot of knowledge into that. So again, I can't. I mean, I could comment on it, but that's not what the debt collection invalidation and stuff is. So it's just not worth for me to go into. I don't know a whole lot about it, and I'd hate to start really going down that hole. I wish I could help you. I just, again, don't have enough information in that. When you're dealing with utilities, that's a tough one, because no matter what, you know, they are definitely going to shut you down if they want to. They're going to take your electric. It's just like dealing with your home. You know, you want to fight your mortgage. Hey, that's all well and good, but you got to know one day they're going to knock on your door and kick you out. You know, and it doesn't matter if you're right. They don't care if you're right. You know, and that's not to say you won't win. I don't want to discourage it. Just be aware of what the possibilities are. You know, I've watched plenty of friends and family lose their homes saying they're going to fight this and they're going to prove that it's fraudulent. And when you're going into the court, you have to remember the court is a bank, and the banks are in bed with the courts, and the courts own the attorneys, and the attorneys are in bed with it's all one big happy family. So you're really taking on a lot. Yeah, so to clarify, hydro is not an unsecured debt. I'm assuming hydro is your water. Is that what we're talking about here? I'm just not familiar with the term, but I'm assuming it's a utility. Utility is, or electricity. Yeah, that's not. It's a utility. That's not an unsecured debt. So again, you could get into certain arguments with that, absolutely, but that's not. This process won't work for that at all. CRA reassessments are unsecured. Will the process work to eliminate the debt? Please clarify the CRA.
Canada Revenue Agency, equivalent of IRS.
Oh, okay. You know, it's funny. I've had discussions with friends in the past who are very, very up on a lot of this stuff, and they believed it would work. But I haven't met anyone that tried it. We won't try it. I'm not going to suggest you try it, But if you see a way through it and you feel that it could work, that is entirely up to you. Um, that's a bigger nut to crack, and you're dealing with a lot more power, you know. So you kind of want to be careful there with that, in my opinion. But I'm going to say, to answer your question, I'm going to say that no, it won't eliminate that debt. Again, because I don't want to mislead anybody and think that this process is going to take care of taxes and things like that. So, um, the consequences of going down this path with regards to credit reports is, again, your credit report is going to get all banged up for the most part. They're going to do all kinds of stuff. Now, you can put in your statement in your invalidation paperwork that they are to remove all the remarks that they put on there. That doesn't necessarily mean that they're going to. What we do at Credit Shield, we send people through another part of the process when they sign up with us. Part of our process is to go into credit restoration. So we take their credit report and we have it scrubbed clean. We get all the remarks off. Even if it's an account that we didn't handle, we scrub all the remarks off of it. Now, I don't want to say me. That's not part of my job or what I do. That's like a subcontractor for us that does that. But the guy's great. He's been in the business for 30 years, and he's given me a lot of insight. It can be done. Again, these laws are all there. Especially when you're talking about the credit reporting agencies, they have to remove the remarks. And what you want to do is invalidate the accounts first. Okay, once the accounts are invalidated, now you can remove the remarks for two reasons. One, it's not a valid account, so it has to come off. And two, they're not going to ding it back up because you basically shut that account down. So your credit report's not going to get all dinged up again. So that's kind of why you want to invalidate everything first. So, I know that most of the bills are for unsecured debts, taxes, utilities, and stuff like that. And that's a very good point. But again, that's not something that these laws were set in place for. So you got to remember, you got to be careful what you're playing with, and you got to know what you're playing with here. I've definitely had my own experiences playing with the big boys. So just be careful what you do. I don't want to discourage anybody from doing anything. I think it's great that people are thinking outside the box like that, but that's going to be something you're going to have to make a decision on your own to do. Um, okay, multiple pay for delete letters to a debt collector without a direct response to my offers and saying I will seek verification. Should I have sent multiple letters with incrementally higher offers? No, no, no. Again, what we're going to focus on here is using the laws and things that they can understand. A lot of that stuff, debt collectors are not the sharpest tools in the shed, and they don't really even understand a whole lot about banking and things like that. So when people are trying to do certain processes to discharge the debt, they have no clue. They don't know what that stuff is. It's a shame. They should. I mean, I definitely think they should. But when they see this stuff, they take it to an attorney because they're like, oh, this is dealing with laws that I'm supposed to be following, and I don't know what they mean, So they take them over to the attorney. Attorney looks at, oh yeah, this is all correct, and you better lay off. So you'll get more of an effect out of it that way. And again, we're just talking about unsecured debt, credit card bills, student loans that aren't federally backed. Things like that, those are things that you can. I mean, man, we've gotten rid of sometimes $120,000 worth of debt for people. I mean, people come with their student loans and they're like up to their eyeballs, and we've gotten rid of it all. So it's really good for those kinds of things. Utilities and stuff, and just different avenues of using discharge methods, so to speak. It's a slippery slope. So, yeah, oh yeah, I figured it was in relation to the credit cards, absolutely. But no, if you basically want to make them verify the account, and there's ways to do that through the law. One of the things is they don't have a contract with you. Please provide, and the other thing is, not only that, please provide a contract with my written signature that I owe you, ABC debt collector, okay, I owe you this money, and number two, put an affidavit there that says I owe it, okay, and sign it, and have it notarized. They will never do that. They will never sign anything. That's key, because you're going to have everything signed and notarized. They're not going to have anything. So your stuff's going to stand a lot firmer than theirs, because they've got no skin in the game, and they won't put any skin in the game because they know if they put skin in the game, their butt is grass. So they're not going to do that. So that's one of the things that you'll want to do is say, hey, where's the original contract? Where is the accounting ledger? I want to see where I was actually lent something from you. Where is the valuable consideration to make this a contract? Where did ABC collection agency lend me however much money you're saying I owe you? Those very simple principles are huge, because that's what it's built off of. So basically, you're definitely. Oh, you're welcome, Antonio. Antonio said, thank you so much. I thought that was the basis of standing up to them. Yep, great. It is. It absolutely is. I mean, it's very simple when you look at the principles and the fundamentals of what it is we're dealing with. I mean, you're dealing with someone you don't owe a debt to that's claiming you owe a debt. So the best thing to do is make them prove up through an affidavit. Everything, when you send your invalidation, you're going to say, everything you send to me must have an affidavit signed that this is true and correct to the best of your ability, your knowledge and ability, and sworn and under seal. Man, they'll never touch that. They won't go anywhere near it. Next thing you know, you're going to get another, you're going to get XYZ collection agency. Oh, we're now collected, because that means that ABC got scared to death and quickly sold it off, because they're like, oh, we can't do anything with this. That's how you know you're winning. Then you go to XYZ and you say, hey, wait a minute, XYZ, here's all the stuff I sent to ABC, and ABC couldn't do anything with it, so you can't either because it's invalid. And I've got all the proof right here that they did not respond. There is no response. Sign an affidavit again. Boom, write up another affidavit, have it notarized. There was no response by ABC. Now you've just put skin in the game under penalties of perjury that they did not respond. That's huge. Affidavits are huge. I know in the United States, and you may know a little more on this for Canada, but in the United States, particularly under the Federal Rules of Civil Procedure, there's two ways to fill out an affidavit, and one is actually without the United States, but under the laws of the United States of America, which is huge, because no one in the government will ever sign an affidavit here under the laws of the United States of America. So when I do an affidavit, I always put that, and I reference Title 28, 1746-1, which is, that I'm under the laws of the United States of America, and here's my skin in the game. And that shuts them down, man. I mean, they don't, there's nothing they can do with that. So again, learning some of those things and researching some of those things is really beneficial and only empowers you. And I know the stuff reads like stereo instructions, and it's hard to sit there and go through it, but you'll be surprised at how much knowledge and power you'll obtain from that. So I have another question. It says, what if the alleged creditor sues you and then you send them the debt validation letter? Is that still useful, or is it too late? Great question. Absolutely, yes, it is too late. If they've already sued you, it's too late, because they usually have given you notice that they're going to do something, they're going to make some kind of maneuver, and that is lawful notice, and you failed to respond, and it's just too late in the game. Now, what you could do, though, is you could, if they haven't put a judgment on it already, you could call up and try to negotiate a settlement and at least pay less. That's probably the best thing to do, and use the hardship thing, and, lay it on thick, and let them, see what they can work out, make them an offer. If they don't accept it, go a little higher, just do the bargain thing. But yeah, if they've already filed a suit, it's too late. A lot of our clients come to us like that. Some of the clients come and they sign up accounts with us they don't even know are in a suit. And then a month or two later, they get a summons, and we do the research and we find out, well, this was already in suit. There's nothing we can do for you, so we have to credit them for that account. We can't really do anything for it. So
I have a question about that.
Yep.
If the debt is not valid to begin with, why would it be still valid even though you didn't respond within 30 days? How does a fiction become a reality because you didn't respond within 30 days?
Well, first off, the debt, it depends. If the collection agency files a suit, again, I would assume they would still have to prove validation. From our standpoint, when we do this, we just don't get into that whole mix of fighting that because we're not going to do that as the company. But I agree with you. I think that a person can go in who knows their stuff and still argue the fact that if it's the original creditor, here's a big one for original creditor. We don't do this. This is not part of my company. This is not something we do. But if you're going up against an original creditor, my thing would be, hey, what did you lend me? Okay, did you lend me money, or did you lend me debt? Did you lend me credit? What did you give me? Please clarify, because when you get down soup to nuts, they didn't lend you any money. And once you define money, the big thing when you go into court, have them define things. So I agree. I think that you probably could if you study enough and you go in and you ask the right questions. One of which is, what did you lend me? You know, where's the other signature on the contract? I only see mine. Who else signed on this thing? Oh, it's implied. You can go round and round with those sorts of things. But in answering that question about going in with the validation process, with this particular process, they're going to look at it as, these are our laws. This is what you're using. No, it's too late. Okay, so this process, I'm going to say, no, you're probably too late to use this process, but that doesn't mean that you still can't go into court and stand on the principles that underpin this stuff. Does that make sense?
Absolutely, yes.
Let's see. Oh, somebody was asking about the title. I'm assuming you're talking about the affidavit title. That is Federal Rules Civil Procedure. It's USC 28, Title 28, 1746 1 is what that is. And that just, there's two ways to write an affidavit, and you'll see that 1746 1 is the most powerful way, because it's under the laws of the United States of America, which is a separate entity from the United States, which is clear, because if it wasn't, how could you sign one without the other? How could you sign under the laws of the United States of America without the United States? You can't. If they're the same, so it just shows you that they're two different entities. So someone said, with any letter I send, I should get them notarized. Yeah, get it notarized when you're dealing with a legal corporate fiction like that. Absolutely. You want it notarized that they witnessed you signed it and sent it that day. Absolutely. It's the best way to do it. And always send your stuff registered mail, return receipt, so that someone signs for it. So now you have, quote unquote, legal proof that it was delivered and it was accepted. Always return receipt on this stuff. Says, each letter I've sent, it was through registered mail, and I have received signatures, but no paper response. Okay, well, that's good. That's awesome. That's how you do it. Now you have proof that you sent them whatever it is you're trying to say you sent. So again, if you're using some sort of discharge method or something, that's fine. That has its own little niche. But again, at least you have proof that it was sent and it was received. Someone said, is there a source for this info particular to Canada? We did find, let's see, we found Canadian.
I did put into the chat box a link to a post which I just built while you were presenting, and it's the $1 million payout, and then at the bottom of the payout is links to Canadian sources. Industry Canada in Canada is the government department that's responsible for monitoring the rules and regulations around bankruptcy and debt collection. So there's a link to their page on debt collection, and then there's a couple other links. One of our members in Nova Scotia kindly sent some links about Nova Scotia collection, and then there's what I believe is a commercial or consumer advocate group at the last link there. If you want to click on that link in the last one in the chat box there and bring it up on your screen, Robert, you'll be able to see it. So this is one of the things that I'm trying to do with the Sue Wrongdoers, is I'm trying to make available the different jurisdictions information. So it's not just specific to Canada or the US or wherever. So if you want to send in links with regards to debt collection, I'll create jurisdictional links for them so that you can see what your jurisdiction is. So there's the article on the $1 million in penalties, and if you scroll down to the bottom, there is some links for the Canadian debt collection stuff. Okay.
Cool. Very good.
Okay.
Awesome.
Now, if you scroll back up to the top, and I'll just show you one of the things I'm trying to do with the website again. Scroll up to the top of that page.
Yep. Hang tight. Let me get my. There you go.
Get your wheelie turning. Click on research. And then you'll see all the different jurisdictions, Canada, USA, UK, etc. If you look on Canada, you'll see more stuff because I've got more research in Canada. And you'll see I'm collecting jurisdictional information for all these different regions. So under BC, I'm going to collect, or under Canada, I'm going to collect a tab for debt collection. And I'll move all the debt collection information there. So you can see that I'm trying to provide a place for everybody who's participating to send links for your jurisdiction. I'll create a page for it and put your links there. So not only for your own reference ongoing, because I always lose links, but for future people coming from your jurisdiction who want to find out what the rules in their jurisdiction, whether it's bank accounts or debt collection or court process or things specific to a city. For instance, if you go to the county, city, municipality there is a Burnaby link because we have an action presently happening in the city of Burnaby. So as we're researching and doing the court stuff with the city municipality of Burnaby, we're collecting links and putting them on a page. So again, it's trying to create a central source for research information. So anybody who wants to contribute to that is welcome to do so. Oh,
Great, that's awesome.
There's some other stuff on the research page. I'm going to be putting up books and dictionaries and various other things as well. So
awesome, very cool. Someone asked, let's see, let me go up a little bit. Oh, someone asked about if after 30 days you didn't ask for verification or validation, can you do so after the fact using nunc-pro-tunc? Well, I will tell you that we have invalidated accounts well past the 30 days because people, quite frankly, forget to get us their collection letters. So we wind up doing it anyway based off of one from 3 months ago, and it does work. I'm not going to suggest that you go that route. What I would suggest is if it's past the 30 days, you call that collection agency and you say, hey, I understand you have my account. I didn't receive a collection letter. Because they've got no way of telling that you actually received it or not. They're just sending it regular mail. Just have them send you another one. And go and just use that. See, because what you're going to do in this process, that's going to be, you're going to attach that to your verification statement and everything that you're putting out, your presentment. You're going to put that in there. You know, you're going to make a copy of it so they'll see the date. So yeah, you just call them and ask them for another one. They don't usually proceed. Their biggest thing, they want to collect from you. If it's not invalidated after 30 days, they're not going to go write the lawsuit. They're going to send you another one, and they're going to keep trying to come after you. So you're pretty good there. You don't have to worry about too much going into that. You can always get another one. Now, if you have an account that you stopped paying on, and you haven't received a collection letter from a debt collector yet, okay, it takes about 6 to 8 months. I've seen it go up to a year before they've actually put these accounts into a portfolio and sold them off to a third-party debt collector. So it takes a while. Sometimes it goes over to the collection agency and you don't even know it's with a collection agency. You can always call the original creditor. You don't want to tell them you're going to pay anything. You don't want to tell them you're invalidating it. You don't want to give them any information other than, I just want to know where my account stands. I have no money. I just want to know who has it. They'll either tell you, we've charged it off and we sent it to ABC Collections. Thank you very much. Can I have the phone number, the name, and the phone number? Then you'll call ABC Collections from there and you'll say, can you please send me a collection letter? Sometimes they'll say, it's not in collections yet. It's getting ready to be charged off and the account's getting ready to be closed and sent to collections in a month or two. They'll actually give you that information. Sometimes they'll say, well, it's here in-house and we haven't sent it to collections yet, and you just got to kind of sit and wait. But that's if you have stopped paying and you haven't received anything yet. So yeah, you could always get another collection letter. Let's see.
And they always like to collect based on making a phone call or sending you a letter. So they're going to do that as long as possible before they take you to court.
Yep, absolutely. So yeah, you don't have to worry about nunc-pro-tunc or anything like that. It's a good idea, but it's easier than that actually. And then somebody asked about the Title 28 thing I threw out there again. Please explain. What that is it's a there's a way to fill out an affidavit, and of course, court rules, federal rules, civil procedure in the United States lays out how you fill out an affidavit, how you swear to it. There's two ways to do that. One way is under the laws of the United States of America without the United States. The other way is just simply you're going to swear or affirm that the facts are true and correct. Period. Doesn't say anything about United States or without the United States. I mean, or it doesn't say anything about with the United States of America or not. Okay. What that means is the United States of America is separate from the United States. They are two different bodies of laws that are happening there, and every single agency or legal uh, entity, government agency, they're all going to use two, okay? They're going to use that Title 28, Section 2. They're not going to use Section 1 under the laws of the United States of America, and as a matter of fact, they can't. So it makes it more powerful because you're standing now in a more solid jurisdiction than they are. So again, I could talk about this for a long time. I don't want to get too far into it, but that's basically the crux of, when you sign an affidavit, my opinion would be, and my suggestion would be to use Title 28, 1746 1 and not 2.
So
So,
effectively, you're making a claim, a statement in the law, and they're making it from the corporate. They're trying to
yes,
stay in the
absolutely.
corporate and stay out of law.
Right, absolutely. So, Section 2 is for them, Section 1 is for you. Just think of it that way. And it shows you how to write it. It shows you how to write your sworn statement and everything. So, you just cut and paste it. I go to Cornell Law for all my USC stuff and other codes and statutes, things like that. So, let's see. I have a question here. I've asked via voicemail response from the creditor to send me written claim. And the collector agency won't even send me anything written. They continue with their pre-recorded calls. I feel I have something to send them something. What should I send them? Okay, first, send them a cease and desist letter to cease phone calls. Okay, it doesn't even have to be anything more than, stop calling me. I'm telling you right now that I do not want to receive any more phone calls. I mean, you want to word it a little more professional, but please stop all phone calls. Only communication should be through the mail. Okay, from that point on, if they keep hitting you with recorded phone calls, great, because now you're racking up $1,000 every time they call your phone. So that's a huge thing you want to do there. Now, if they're not sending you a collection letter, there is no real way to force them to send you a collection letter. But what we came up with was we made up. It's called a data collection sheet, and what we do is it basically, and I can go over that with you too. I can put that up. Basically, you're just filling out the date and time that you called, who you spoke to. You're going to call the actual collection agency, who you spoke with, date and time, the original creditor account number, the original balance, the debt collector's name or the debt collector's address, phone number, the amount that they're claiming you owe them, their account number, because the debt collectors assign a different account number, their own in-house. And there might be one or two other things on there that I'm not remembering off the top of my head. And you can use that in lieu of a collection letter. So, but yeah, I know you're asking to see sample paperwork and all. I didn't come prepared with that tonight because it's a lot to get into. And yeah, I can definitely show you guys a sample of that. I can't show you a sample of what we use at my company, again, because they have that particular process and stuff patented, but these are laws that anybody can use. All you have to do is use the same principles, and what we'll do is we'll start drafting that up and put that up so you guys can see and use that. So
Just
yeah, we'll get some stuff together.
on that note, just put in the chat box yes if you're interested in getting more information, having some sort of course or process and some materials to do that, because this this webinar was put together rather quickly. And like he says, you can only cover so much stuff in an introductory. So just put in a yes there, just so we can get an idea of how many people have an interest. And I'm sure it's something that we'll do, but the more people are interested, probably the more urgency behind getting it done, I suppose. And that,
Absolutely.
and that, of course, wouldn't be until sometime in the early part of the new year.
Yeah, you guys got to remember, you got to bear with me because I'm going to be doing this all from ground up because I'm not using my company's paperwork or anything. And I have an 8-year-old son, and I've got a lot personally, so I'm going to do all this. But you got to bear with me with time. I'm going to get it all done,
Well,
and I
it
want.
took me 6 months to get you on to do a webinar, so
Well, there were some personal things going on that had to clear up a little bit
I
too.
know, and because we've done this, I know it'll move much more quickly, and there is an interest. There's a bunch of
Yep,
people who are putting in yes, yes, definitely, etc. So yeah,
absolutely.
I'm sure it'll happen, and everybody will be getting updates from the website about it, and we'll have we'll let you know what's going to transpire and all that sort of stuff, how it's going to be put together, and so on. The other thing is. This is going to be posted on Sue Wrongdoers as well as Private Person. It'll be up on both websites. And anything in terms of notes that Robert has that he wants to include, including any of the links, like the US links, I'll put them up there, etc. So the resource will be there for you to review. And then as information comes out with regards to what we're going to do as a next step with it, we'll all let you know. Okay?
Absolutely. We're it looks like we're getting close to time here to cutting off, but I did have one more question I just wanted to um, address real quick. It just came in. It says, "Can you comment on how it's not real money you were lent?" Yeah, I mean, you got to understand what real money is when you get, even if you got dollar bills in your pocket, you don't have real money. If it says note on it, it is a note, which is a promise to pay. Again, these are terms that you want to look up in your law dictionary. A note is a promise to pay. So in our system of money around the world, it is a debt-based system for the most part. Most of the countries, anyway, it is a debt-based currency system. So how can you pay a debt with a debt? You cannot pay a debt with a debt. So what happens is you're basically just discharging back and forth. So what is lawful money? Well, here in the United States, lawful money is defined as gold and silver in the Constitution. So now what we have is a fiat currency. So again, where was the value that you lent me? I'd like to see a ledger of accounting that shows value that you actually took risk. Not from some portfolio of more debt being exchanged. So those are the types of things you want to start to understand to be able to ask those questions. So
But you don't have to understand all of that to go through the process of sending out the letters and asking for the specific information to validate it. You don't have to understand it at that depth. It's good to know something about it, but that's getting deeper than, here's the principles of what you have to do to verify. And for most people, is that sufficient?
right, yeah, you don't really even need all that, unless you're gonna carry the torch and fight this thing further. If it goes further, that's a personal choice, and it just takes some study. There's tons of stuff on the internet, guys, that you can look this stuff up. And all I can suggest to you is that when you do find someone who is really knowledgeable or appears to be really knowledgeable about this stuff, just make sure you check the research. Make sure you check the particular historical documents and laws and things that they're saying make this an actual real thing, instead of just something that they're misconstruing or copying and pasting from someone else. So, but yeah, I mean, tons of information out there right now. Tons of really good people to learn from about all this stuff. But for our purposes here, everything that we have, we can do right here. I work for a company that we do this all the time, so we have it for unsecured debt. We can invalidate that all day long. So we've got that down pretty much.
Cool. Cool.
Yeah,
So on that note, I think we can wrap up today. Be just a few minutes early, and thank you very much for coming on and sharing your knowledge. And it's obvious you know what you're talking about, and have done lots of it. And that's one of the things that's great about finding somebody who's well grounded in their information. So appreciate you sharing with us, and look forward to more in the near future.
absolutely. Thank you. I appreciate it too, and I always enjoy passing this information on. You know that. So that's
Okay.
awesome.
Well, everybody have a great rest of your weekend, and we will talk to you soon. Take care.
Thank you, everybody. Take care.